Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today, we break down the February 24th, 2026 Supreme Court opinion in United States Postal Service versus Konan. In a 5-4 decision, the court ruled that the postal exception to the Federal Tort Claims Act shields the government even when postal workers deliberately refuse to deliver your mail, not just when they mess up accidentally.
Justice Thomas wrote for the majority. Justice Sotomayor fired back with a sharp dissent, accusing the majority of handing the Postal Service blanket immunity that Congress never intended to give. Before advancing, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. Questions about this case? Reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
By the way, you might have seen, on Wednesday, February 25th, the High Court Report released its interview with Dr. Adam Feldman. Dr. Feldman publishes incredible works grounded in Supreme Court data. I really enjoy his work. I've cited his works here on this podcast in other episodes. We interviewed Dr. Feldman about Supreme Court timing patterns. Best of all, we got his instant reaction to the Trump tariff case's ruling. Check out the interview to hear his insights.
All right, let's get into it. Today, we tackle Postal Service versus Konan, a case about what happens when postal workers don't just lose your mail, but allegedly target it on purpose.
And the answer, according to 5 justices, tough luck. Let me set the scene. Labine Konan owns 2 rental properties about a block apart in Euless, Texas. She rents out rooms and collects mail at both addresses. Starting May 2020, she claims postal workers launched a coordinated campaign to cut off her mail.
What did they allegedly do?
First, a carrier switched the listed property owner from Conan's name to a tenant's name, no authorization. Then that same carrier changed the mailbox lock and gave the tenant access. Konan never agreed to any of this. It gets worse. A supervisor froze all delivery to her first address, claiming they needed to investigate. Mail sent to Konan and her tenants started bouncing back to senders marked undeliverable. Then, postal workers discovered she owned the second property down the street and killed delivery there too.
Hold on. They connected the 2 properties and shut down the second one?
That's her allegation. A red notice popped up inside one mailbox, listing only certain people as authorized recipients. When Konan showed up in person to retrieve her held mail, workers refused to hand it over.
What drove all this, according to her?
Racial hatred. She claims the postal workers despised her words that a black person owned these properties and leased rooms to white people. So she sued the federal government
Under the Federal Tort Claims Act, the FTCA. That law generally lets people sue the government when federal employees commit torts, but Congress carved out exceptions. One of them covers postal claims.
What does the postal exception actually say?
The FTCA's immunity waiver does not apply to any claim arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. 3 terms: loss, miscarriage, negligent transmission. The whole case turns on what those words mean.
The district court tossed Konan's lawsuit. The postal exception bars all non-delivery claims. Intent doesn't matter. The Fifth Circuit flipped that ruling. Loss, miscarriage, and negligent transmission don't cover intentional refusal to deliver mail, creating a split among federal appeals courts. The First and Second Circuits said the postal exception applies even to intentional misconduct. The Fifth Circuit disagreed. The Supreme Court stepped in to break the tie.
Let's unpack the majority opinion. Justice Thomas wrote for 5 justices. Himself, Chief Justice Roberts, Alito, Kavanaugh, and Barrett. He opens with the policy picture. The Postal Service employs over 600,000 people, delivering more than 300 million pieces of mail every single day. Letting people sue over delivery problems would bury the government and courts in litigation. Plus, damages would depend on what's inside the envelope, something the government can't control or predict. A love letter, minor damages, $1 million contract, massive exposure. Congress apparently decided those risks outweighed individual plaintiffs' ability to recover. The question, Did Congress extend that protection even when workers act maliciously?
Start with miscarriage.
Justice Thomas pulled out dictionaries from the 1930s and 1940s, around when Congress passed the FTCA. They defined miscarriage as male, failing to reach its destination. No intent requirement anywhere.
But couldn't failure imply carelessness?
Konan pushed that argument. The majority shot it down. Old newspapers described mail as miscarried, when thieves stole it or arsonists burned it. Courts accepted miscarriage as an excuse for missed legal deadlines, without asking whether the carrier acted intentionally or carelessly. The word applied whenever mail didn't arrive, full stop.
Now loss.
Here's the majority's key move. Justice Thomas focused on what the plaintiff experiences, not what the postal worker does. Webster's defined loss as suffering deprivation. You suffer deprivation when someone deliberately withholds your property, not just when they misplace it.
So even if the worker acts on purpose, the plaintiff still experiences a loss.
Precisely. Historical newspapers and court decisions described loss of mail from theft, including theft by the carriers themselves. The statute targets claims arising out of the loss, the harm experienced, not the conduct causing it.
What about that word negligent, sitting right there before transmission?
Konan seized on this. Look at the structure: loss, miscarriage, or negligent transmission. If Congress wanted all three terms limited to careless conduct, why stick negligent only before the last one?
The majority brushed it aside. An adjective before the last item in a list doesn't automatically apply to the earlier items. Congress deliberately put negligent before transmission alone. That word just clarifies the transmission means mail delivery problems, not every aspect of mail handling.
Konan also argued the majority's reading makes loss and miscarriage redundant.
True. If miscarriage means failed to arrive and loss means deprivation of mail, they overlap heavily. The majority acknowledged this, but concluded Congress probably used broad, overlapping language precisely to keep mail complaints out of court. Redundancy concerns take a backseat to ordinary meaning.
Now, let's hear from the dissent. Justice Sotomayor wrote for 4 justices: herself, Kagan, Gorsuch, and Jackson. Notice that lineup. Gorsuch joining the 3 liberal justices against the conservative majority. Unusual coalition.
Sotomayor comes out swinging. She accuses the majority of transforming rather than honoring the postal exception. Her central complaint: Congress picked specific words, loss, miscarriage, or negligent transmission, instead of writing broad immunity. The majority erases that choice.
Break that down.
Congress could have written any claim arising from mail activities of the Postal Service. It didn't. By selecting particular terms, Congress signaled a narrower exception. The majority hands the Postal Service exactly the blanket protection Congress refused to grant.
The negligent modifier forms her strongest textual argument.
Absolutely. Congress knew how to exclude intentional wrongdoing. It wrote negligent transmission. Under the majority's reading, Congress wasted ink. Any intentional misconduct that negligent supposedly excludes gets swept right back in through loss or miscarriage.
She also attacks the majority's definitions.
With force. On loss, she writes, no one intentionally loses something. You lose your keys when they slip behind the couch, not when you hand them to someone. You lose your mail when it vanishes in the system, not when a worker deliberately destroys it.
Even the government admitted that.
Yeah, in its own cert petition, the government conceded loss ordinarily captures unintentional conduct. Sotomayor highlights that confession.
What about miscarriage?
She argues the majority found almost no evidence that people commonly used miscarriage to describe intentional failures to deliver mail. The majority's 2 newspaper examples came from 30-plus years before Congress enacted the FTCA. Hardly proof of what Congress meant in 1946. She spots a structural inconsistency, too.
A sharp one. The majority claims all 3 terms describe harms rather than conduct. But watch the definitions. Miscarriage: harm to the mail, it failed to arrive. Negligent transmission: harm to the mail, it got damaged in transit. Loss: suddenly harm to the plaintiff. She suffered deprivation. Why would Congress describe 2 male-focused harms and 1 person-focused harm?
What's the better reading?
All three terms describe what the Postal Service did. The service's loss, miscarriage, or negligent transmission of mail. Under that framework, loss plainly implies inadvertence. You can't deliberately lose something.
The majority worried about a flood of litigation. Sotomayor responds,
She dismisses that fear. Other FTCA safeguards would block most claims based on intentional wrongdoing. Most states exclude intentional torts from the scope of employment. So those claims fail anyway. The discretionary function exception shields policy judgment. The due care exception protects reasonable decisions. Courts can sanction frivolous claims under Rule 11. The litigation flood never arrives.
Bottom line, what does this ruling mean for real people?
The Postal Service now enjoys broad immunity for mail delivery decisions. Whether workers act carelessly or maliciously,
Even discrimination?
even that. Konan alleged postal workers deliberately blocked her mail because they resented a black woman owning property and renting to white tenants. Under this ruling, she cannot collect damages through the FTCA.
Any recourse left?
Precious little through federal tort law. Her case goes back to the Fifth Circuit, but the writing looks grim. The court left open whether every single claim falls within the exception and which arguments she preserved, but the majority made its direction clear.
4 justices see this as the court expanding immunity beyond what Congress authorized. 5 justices see themselves following ordinary word meaning without adding intent requirements Congress never included. Classic interpretive standoff.
The court prioritized dictionary definitions over statutory structure. Failure to arrive and deprivation carry no built-in intent limitation. Congress put negligent only before transmission. The majority refused to import that modifier into the other two terms. The postal exception now operates as near total immunity for mail problems. Whether a carrier misplaces your birthday card or deliberately trashes your mortgage documents out of spite, same result. You can't sue.
That's Postal Service versus Konan, a 5-4 ruling with major consequences for anyone claiming postal workers targeted their mail intentionally.
And a surprising split, Gorsuch joining the 3 liberal justices in dissent.
Thanks for listening to today's High Court Report episode. Follow, rate, subscribe, and share the podcast on Apple, Spotify, YouTube, wherever you get podcasts. Follow on LinkedIn for written summaries. Just search the High Court Report. Questions about this case? Reach out via LinkedIn or email at scottis.cases.pod@gmail.com. Talk to you soon.